My name is Katie Gallagher. I'm an attorney at the Center for Constitutional Rights in New York and a member of this year's annual meeting committee. And I'm very pleased to be with you all today, and again, appreciate you coming to this late-breaking panel, and to our panelists for coming and speaking and sharing their experience and knowledge with us today. On March 17th, the International Criminal Court issued an arrest warrant against Vladimir Putin, President of the Russian Federation, and Maria Lvova-Belova, Russia's Commissioner for Children's Rights. The warrant focuses on war crimes related to children, the unlawful deportation of population and unlawful transfer of population from occupied areas of Ukraine to the Russian Federation. The ICC opened a preliminary examination into the situation in Ukraine nearly 9 years ago, following attacks on the Maidan protests, extended it the following year after the annexation of Crimea, and the former prosecutor, Fatou Bensouda, indicated that there was a sufficient basis to open an investigation into Ukraine in December 2020. But due to lack of resources, she did not do so. In March 2022, after the full-scale Russian invasion of Ukraine, Prosecutor Khan announced the opening of an investigation. So the issuance of arrest warrants in the Ukraine situation has been a long time coming. And here I want to particularly commend Ukrainian human rights organizations and civil societies which pressed for years in the hallways in New York, on the sidelines of Assembly of States parties meetings, and at home in Kiev, pressing to hold the powerful to account. And yet the announcement both of the target and the focus of the crimes still marked a pivotal moment in international criminal justice of the ICC and was met with a great deal of commentary. It also raises many questions. What are the implications of an arrest warrant against a sitting head of state, of a non-state party to the Rome Statute? What are the obligations on member states to effectuate the arrest warrants? Given the specific nature and type of crimes that are the focus of the arrest warrant, what does this signal? These are some of the questions that this esteemed panel is going to address in the very short time we have today. So I will forego extensive introductions and instead get right into questions. We are going to start with Professor Diane Marie Amen from the University of Georgia School of Law. Professor Amen, crimes against or involving children have long been a concern to international law, as evidenced by forcible transfer of children as one of the underlying acts of genocide, and by those impacted by it who continue to tell their stories, like the stolen children and the families in Argentina's dirty war. As the former advisor to the ICC prosecutor on children in and affected by armed conflict, can you provide an overview of the charges underlying the arrest warrants and speak to their importance?
Thank you very much, Catherine. I would be happy to do so. Let me say first, although I did have the honor of being the first ever special advisor to the ICC prosecutor on children in and affected by armed conflict, I completed that service with the conclusion of Fatou Bensouda's term in 2021, and of course speak only on my own behalf. I have asked staff to put up this photo to orient us to what's at stake here. This is a photo made in October of 1947 in the iconic courtroom at the Palace of Justice in Nuremberg. It was made by Ray Daddario, one of the foremost photographers of the proceedings, and it concerns one of the 12 subsequent proceedings run by a US-led prosecution and judicial bench aided by participants from around the world. The caption states in part in introducing this picture that these are 9 of the defendants in what was known as the Russia case, Russia being an acronym for something that translates effectively to the Race and Resettlement Agency of the Nazi regime. And you see there are 9 SS officers and Inga Vermeets, who was an assistant to one of those officers. The caption reads, "The defendants are charged with kidnapping foreign children to be reared as Nazis by German families." And the children were kidnapped from the very regions that are at stake in this arrest warrant. Most of those charged were convicted of at least one of the war crimes or crimes against humanity charged, and several of them hanged for their crimes. I show this photo to remind us that there is a direct link to the March 17 arrest warrants against Mr. Putin and Ms. Lvova-Belova and the founding era of modern international criminal law. It also serves as a reminder that crimes against and affecting children, the centerpiece of these warrants as they now exist, have that long tradition, and that it's appropriate that they do so. Sometimes we hear commentary belittling or talking about crimes against and affecting children as if they're somehow a placeholder or minor, and I would submit that that is not the case. Crimes against and affecting children have a unique moral pull and a unique factual pull. We pretend as a global society to care more about children. I frankly don't believe we do, or we wouldn't treat them the way that we do. But we certainly have the pretense about caring about children. And factually, as people who endure crimes in armed conflict, because they are younger, they will carry the consequences longer. Not only that, they are, in fact, a society's future generations, and so the traumas, the burdens, the resentments that they carry are that much more likely to be passed down. Finally, as the Nazi reminder makes us remember, to take a child out of his or her or their own society and take them somewhere else and turn them into a member of a different society is truly the most heinous crime at either domestic or international law. And it deserves to be treated as such. Indeed, the Russia trial was a trial about eugenics, notions of master race, etc. I will note before I make a couple other points, moving off of the photo, it is not an accident that the guards at this trial are African-American troops. That was a choice made by the Army at a time when the Army was still segregated in the United States, but they wanted a very visual demonstration against the master race notion. And so many of the guards in the subsequent proceedings were part of the black contingents that were present at Nuremberg. It's not just those two polar events that have this, and I'll very quickly cite, the line goes through the Barbie trial, where one of the signature crimes dealt with the kidnapping of children from an orphanage and transport to Auschwitz, where they died. The Sierra Leone court, the Cambodia tribunal, dealt frequently in its judgments with crimes against and affecting children, and of course the ICC dating to the Lubanga trial and going forward. I'd also note that this is not the first prosecutor to care about this crime. It has been a common thread through all three prosecutors. Lubanga was charged in the first. In the second, we had both the conviction in that and other cases, charges being broadened beyond simply child soldier charges, and the development of the policy in 2016, on which I had the privilege to work, in which the new prosecutor, as part of his commitment to center children in the narrative of victimization in armed conflict and similar violence, has begun to refresh, if you will. And so I'll just end with his comment when he announced the arrest warrant, which was, "We cannot allow children to be treated as if they are the spoils of war." And you hear echo there of the language that was used perhaps 25 years ago with regard to crimes against women and sexual gender-based crimes. I'm sure that wasn't accidental. This is part of a move to make us as a global society take responsibility for our children. Thank you.
Thank you very much, Professor Amen, for grounding the conversation today. We will continue on and hear from Professor Sarah Mohammed from the UC Berkeley School of Law. Professor Mohammed, looking at the ICC from the outside, what do you view as the goals of the prosecutor and the court in bringing and affirming the arrest warrants? How do you see this development impacting the larger public's understanding of what is happening on the ground in Ukraine?
Thanks for those questions. Thank you for those questions. And I want to start by thanking the annual meeting committee for putting together this terrific event and for pulling together this late-breaking panel. So I think there's been a lot of discussion at this point about the potential effects of this arrest warrant, the potential for the warrant to isolate Putin internally, perhaps increase elites' frustration with his choices, especially as they find themselves perhaps unable to freely travel, wondering about their own futures. There's the possibility of isolating Putin internationally, right? The Ukrainian prosecutor general has said, now world leaders will think twice before shaking his hand or sitting with him at the negotiating table. I'm going to focus more on the goals that the court may be pursuing and also the narrative impacts of the arrest warrant. So one goal that the court announced explicitly is prevention. So the ICC press release that accompanied the announcement of the warrants notes that the crimes are ongoing and expresses a hope that public awareness of the arrest warrants will stop the further commission of these crimes. So does this mean that the arrest warrant is aimed at stopping Putin himself? Probably not. But I think there's at least a potential for deterrence of mid-level actors from engaging in these particular acts. Russian authorities, of course, have said more child deportations are on the way. The literature on the direct deterrent effects of international criminal prosecutions isn't heartening. But we might still wonder whether for actors below Putin and Lvova-Belova, this might potentially change the calculus of the costs and benefits of the child deportation program itself. So will this end the war? No. Will this mean fewer children who are abducted and taken across the border and subjected to military training and forced to be in Russian propaganda campaigns? Perhaps. Russian authorities have done this right out in the open and have insisted that the programs will continue, but perhaps. So what about the goals that the court hasn't explicitly identified? Well, a number of commentators in the last few weeks have framed reactions to the warrants around the question of whether these are merely symbolic because Putin won't be arrested and tried anytime soon. I think that's the wrong framing. Some of the goals and functions are symbolic, but the symbolic functions, which I'd put under the broader category of expressive functions of law, they're powerful and crucial. They are not mere. We can see these warrants, for one, as an opportunity that the court is taking to show solidarity with victims of crimes in Ukraine. For some victims, at least, the acknowledgement by an international court of the crimes that they have suffered and of the responsibility of the Russian president for those crimes, that matters. It's not everything. It's not going to end the war. It's not going to rebuild the families and communities and towns that have been ravaged, but it's something. Scholars like Sarah Nowen and Sarah Kendall and my colleague at Berkeley, Laurel Fletcher, have offered powerful insights on judicial understandings of victims. And I want to be careful here not to imagine a monolithic victim population that has one reaction to this arrest warrant. But at least for some, especially in a state that itself is focused on its own criminal system of prosecutions for crimes undertaken during the war, the attention of the ICC and its willingness to issue an arrest warrant against Putin himself may be particularly powerful. It may be especially important given the fractured global reaction to the war. There's obviously a very different sense of the stakes and the appropriate resolution in the global south, and at a time when support even in Western states may be waning too. So public opinion polling in the United States shows softening support for US assistance to Ukraine, and there are some prominent Republican voices that have opposed US support for Ukraine. I think this is not only about a message being sent to victims, this is also perhaps a way to establish the ICC as the central institution in responses to the war. This may be, of course, why we're not seeing a sealed indictment, or why this isn't a sealed indictment, we wouldn't see it. For the court, this is a way perhaps to say, the world doesn't need an aggression tribunal. We can handle Putin ourselves. This is, of course, a gamble, I think, as any prosecution of the leader will be, right? We have a lot of attention right now on whether he will travel, say, to the BRICS summit in South Africa, whether South African authorities are going to arrest him. I think as much as this may be sort of an effort to establish the ICC as the central institution, right, that may not be a successful effort. This depiction of the war as a battle between authoritarianism and democracy is one that, of course, isn't shared across the world. The insertion of the ICC into the conflict may add to those divisions in reaction. So Putin has portrayed this as a war with the NATO. Perhaps he'll add to that, this is a war with the ICC. I want to end just by saying a little bit about criminal prosecutions and narrative. And I think that this arrest warrant against Putin in particular is quite interesting and important on two fronts. One is about the ways that criminal law reckons with abuses of power, and the other is about what is emphasized and what's left out when we let criminal prosecutions do the work of storytelling. So on power, I think we cannot, forget the fact that it means something that this is an arrest warrant against the top person, a sitting head of state of a very powerful state, of a permanent member of the Security Council. I think any accountability effort that's aimed at individuals at the top of a hierarchy offers anyone watching an opportunity to better understand and to condemn the ways that individuals use positions of power and authority to influence other people to commit crime. So we should be thinking not only about how a leader uses power over others and power over institutions to plan and organize and use the mechanisms of the state to accomplish wrongdoing, but we should also be thinking about how this person uses that power and authority to create the psychological and moral conditions that convince other people to commit crime. So ideally, prosecutions of people at the top open up an opportunity to examine how leaders use purported justifications, a perception of threat or necessity, a claim of benign humanitarianism in order to exploit and influence others. And ideally, prosecutions might impel those who are being influenced, the lower level perpetrators, the Russian families, right, taking into these children, to rethink and to question those justifications. And then second, on the emphasis in what's being omitted, I think Diane really powerfully pointed out how important it is that these are the charges, right? It brings attention to crimes against children. It brings attention to the real gravity of these crimes. At the same time, I think, we're living in a world, for those who sort of care about what the court is doing, we're living in a world in which criminal prosecution is a way of showing that something matters, and the omission of what is available for criminal prosecution also signals that something doesn't matter so much. So we are being shaped by the crimes that are under the jurisdiction of the court. We are being shaped in how we think about these events, in the crimes that show up now or perhaps in the future on arrest warrants, and we're being shaped by what isn't considered a core crime. So my own research right now is focusing really on our absence in international law of adequate language and legal frameworks for addressing how a state treats its own service members. There isn't really an adequate way under the Rome Statute to address the fact that Putin is sacrificing masses of lives to this war, and that under international law we continue to tolerate the treatment of military service members as cannon fodder. And so as much as we may celebrate the attention that we can pay to these crimes that may be ignored in other contexts, I urge us to also think about what's being left out of these mechanisms. Thanks.
Great. Thank you so much for all you covered there, and this deterrent value internally and externally, I think, gives us a lot to build on as we continue. Next, we will hear from Professor Javier Escoriaza from the University of Nottingham. Professor Escoriaza, can you put these arrest warrants in the larger trajectory of justice for Ukraine? Do they mark an inflection point 8 years after the annexation of Crimea and a year into the full-scale invasion? How, if at all, do you see them featuring into any resolution of the conflict or even post-conflict justice?
I can try.
In about 3 to 4 minutes.
Thanks, Katie, and thanks for inviting me to be on the panel. So what I've been thinking about for a few years is something called jus post bellum. It's a sort of umbrella term. It's a broad church. And thinking about conflict from the perspective of post-conflict does change things a little bit. So if we begin with the premise that this conflict is going to end, like many conflicts, in a negotiated settlement, that's messy. And that's a world of uncomfortable agreements. And what some theorists like Larry May like to refer to as myonexia, which is this Greek principle where justice is accepting less than what you are actually entitled to. And we see international law be quite innovative in these post-conflict situations, Colombia being perhaps the example, I would suggest, of a really, really complicated agreement which sort of mushroomed into an incredibly innovative set of institutions. And it might seem odd, and even at worst, it might seem distasteful to talk about peace when the conflict is very much still hot. But I do think it's useful to think about it. And in that perspective, I think there are a couple of things, and I'll just highlight, because obviously we're in the middle of this. The first is that the ICC arrest warrants will be interpreted differently depending on the party, right? So have we considered that for Putin, these arrest warrants are a threat? I mean, what was Putin's response? Was to mention that he was going to put nuclear weapons in Belarus. So we have to consider the moves and sort of be cautious about what we're actually communicating across in international relations. They're also obviously an obstacle. You've got to make peace with these people. You've got to sit around a table and try to figure out a way of dealing with the crimes. And if one of the people that you've identified is the person that you have to make peace with, barring, the caveat that it could end up in a different way. I'm working on the premise that this will be a negotiated settlement, which is messy. Then obviously you have to deal with these arrest warrants and, what exactly the effect of the warrant will be on the peace negotiations is unclear. We're in a pre-negotiation phase, a jockeying for position, territorially but also legally and morally. Will it even be Putin on the other side of the table? All these things it's very easy to say something really silly at this point because we're right in the middle. So that was my sort of first point that I'd like to sort of mention. I think I'll leave it there because we've got more people to talk. Thank you.
Thank you, and we will definitely circle back. Next, we will hear from Professor Marko Milanovic from the University of Reading. Professor Milanovic, zooming out even farther, and maybe staying within the confines of a time, unfortunately, still of conflict, what can address some of the can you address some of the jurisdictional issues implicated through these arrest warrants, whether Russia's status as a non-state party or Crimea's status as occupied territory? What are some of the particular legal aspects and potential precedents for other situations we might see develop here?
Thank you, Katie. Thanks also to the organizers for having me and for having this panel. Basically, I'd like to make 2 points. So first, on the jurisdiction issue. It is clear that the jurisdiction of the court is essentially based on the territoriality principle. The crime charged occurred in the territory of Ukraine. Ukraine, even though it is not a state party to the Rome Statute, under Article 12, Paragraph 3 of the statute, made a declaration accepting the jurisdiction of the court. Ukraine, like any other state, can delegate to some other state or to an international tribunal the exercise of its own jurisdiction. That is essentially the jurisdictional framework that the ICC applies for any kind of atrocity crime that happens in Ukraine. Now, the interesting issue here is that this is a cross-border crime, right? So the children are taken from Ukrainian territory into Russia. This issue arose already in the Myanmar situation, where on the basis of the fact that the Rohingya from Myanmar were being expelled into Bangladesh, which is a state party, the court could establish its jurisdiction. It's just in reverse here. The children are being taken from Ukraine, which accepted the court's jurisdiction, into Russia, which is not a state party. So from a jurisdictional standpoint, the question that the court will have to confront in some cases will be, to what extent can some criminal conduct that takes place on Russian territory be taken into account in prosecutions before the court, right? So that's the jurisdictional issue in a nutshell. The implication, of course, of this is that this goes back to that long-standing debate essentially initiated by the government of this country, that the court has no right to exercise jurisdiction over nationals of non-state parties. And that was always a manifestly mistaken argument made purely in the interests of the United States as an imperial power. It was always seen as such by basically everyone outside the United States. It is high time for the United States to renounce that argument and to say, just like now, I, as a British and Serbian national, if I commit an offense on American soil, I can be prosecuted in American territory without the permission of the United Kingdom and Serbia. In that same way, an American service member who commits a crime on an offense on the territory of a non-state party, or a Russian service member who commits a crime on the territory of a state that accepted the jurisdiction of the court, can be prosecuted. That's it. That's the correct legal position, right? Everything else is simply, self-interested types of arguments that are really meant to avoid submitting powerful states to the jurisdiction of the court. That said, Russia, as a non-state party, has zero obligations to cooperate with the court. So even though its nationals can be subjected to the jurisdiction of the court, the state itself has no duty to comply with any kind of request by the International Criminal Court to cooperate. So that is the jurisdiction in a nutshell. Now, there is a very interesting set of incidental issues that arise in this type of case in particular. So the second charge is under Article 8b(8), I think, of the statute, which is about transferring the part of the population of the occupied territory into some other territory, into the territory of Russia itself. Now, that means that incidentally, the International Criminal Court has to decide, as an element of the offense, whether the territory in question is in fact Ukraine's own territory, whether it's occupied territory. And as you know, Russia, of course, purports to have annexed this territory. Russia's argument is that this belongs to us. The crime did not happen because it's Russian children being taken to some other part of Russia. That's what they would say. Yeah? So incidentally, the ICC essentially will have to determine sovereignty over this disputed territory. And this kind of problem arises in other contexts as well. The European Court of Human Rights can, in many types of situations, depending on the human right at stake, also have this kind of incidental jurisdiction. So, for example, one protocol to the convention guarantees the right to return to one's own country. And you can say, incidentally, the European Court of Human Rights has this kind of jurisdiction to determine sovereignty disputes. So the court can do this. It is a part of the elements of the crime, and the court can make this determination, even though, again, Russia never accepted the jurisdiction of the court. Yeah? This will happen. Now, temporally, what's particularly interesting here, of course, is that it's very unlikely that these cases will get prosecuted to conviction, right? However, there is a particular procedural step in the Rome Statute under Article 61 of the statute. That's the confirmation of charges. In all, people who know ICC stuff better than me can correct me if I'm wrong, but in the past 20 years or so, the court has only done these confirmation hearings pursuant to paragraph 1 of that article once the defendant has actually been apprehended. However, under paragraph 2 of Article 61, they can conduct this confirmation of charges in the absence of the accused, if various criteria specified in the article are met. I am pretty sure that the prosecutor will ask for this. And then it will be fairly soon, so within the next few months, a year, I don't know, that the International Criminal Court will have to, at least the pretrial chamber, will have to decide on some of these questions. And another interesting point that arises is that it's not simply that the sovereignty of the territory is part of the objective elements of the offense. It's also that the defendants can potentially raise it as a defense of mistake of fact or mistake of law. So, for example, Maria Lvova-Belova can say, I honestly believed that this was Russian territory. So that means the element of the crime that requires you to intend or to know that this was occupied territory is negated. Article is at 31. Yeah? And so it'll be very interesting to see again whether court-appointed counsel will raise this as a possible defense in the confirmation of charges hearing and what the court will say about this. This mistake of fact / law issue is particularly interesting when it deals with this kind of evaluative mistakes. It's not simply that, I shot at the wrong man, and so that's a mistake, a pure mistake of fact. This is a kind of normative assessment. Is this our territory? Is this not our territory? And they will be able to say, well, I relied on the advice of our lawyers. My superior told me that this is Russian territory in the case of Maria Lvova-Belova. And we'll see what the court will do with that. So it'll be a very interesting set of issues to look at.
Thank you. Yes, that gets into some of what we heard about following orders and, torture maybe being lawful. Mm-hmm. So moving on and maybe building off of what Professor Milanovic said about some of these threshold questions, Professor Amen, can you drill down a bit on the charges and the targets that we currently have and what we might see come next? Will we see potentially crimes against humanity after these initial war crimes charges? Why Vladimir Putin for this crime base? And is there anything particular of note that his co-accused is a woman?
All right, let me tackle a couple of those. I think Sarah spoke very eloquently to the choice of Putin, and I think I might want to leave it there, except to say that, in my view, international criminal law is inherently and historically an expressive activity, and I think that we should never discount the expressive force of things that are done within tribunals, even at a stage as early as the issuance of arrest warrant. It is significant, and we should note that. I think it's also important to remember with this idea that this is somehow a minor charge. Marco has just made clear these are profoundly difficult. Succeeding and securing a conviction before the International Criminal Court is a Herculean task, not only because of all the evidence-gathering challenges. The other side in this case is one of the most powerful nations in the world, and will stiffly resist everything, both in evidence and law, not only because the statute is so complex, not only because all the participants are multinational coming from different legal traditions, but also the elements of the crime as interpreted by judges in the brief history of the ICC has been profoundly strict. If you compare the level of inquiry into facts and law by the Nuremberg tribunals to those of the ICC, you see something that, even though it's an international setting, many of the judges see themselves as operating in domestic criminal systems, perhaps because they came from those, and expecting that level of precision in a case. And that's something really hard to deliver at the international level. So even these will be very difficult to prove. Why just war crimes? If you look at the prosecutor's statement, it appears that that's where the crime base was. He's identified a couple of orphanages or care homes for children where children were literally taken out and transported. And they have some evidence that at least 100 of them have been, or several of them have been adopted. And so it feels like there is a match of the evidence to the crime base. There may be a desire to test some of these law of armed conflict issues with a narrower case. We also have the opportunity for putting pressure on participants, including those already charged, by leaving the other potential crimes out there, like crimes against humanity. Unlawful deportation is potentially a crime against humanity. And then I think also the thing that would be interesting to wait to see is if this eventually evolves into the first ever charge brought alleging forcible transfer of children from one population to the other as an act of genocide. That has never been litigated since the Genocide Convention, but depending on how things sadly develop, that may be a potential. As for the fact that it's a woman, I think there's been some people saying, oh, there's only been 7 in the modern era. Well, there was thought of indicting a woman in the first Nuremberg trial, Bertha Krupp. It was decided not to, but it was contemplated. 2 women, as we see, were charged, 1 convicted in the subsequent proceedings, and in the zonal trials that were held by British, French, and other Soviet military officials, there were hundreds and hundreds of women charged with acts of quite severe brutality, often camp guards. The one thing that I think we need to watch, in addition to simply accepting that when people get into certain places of power, they may find themselves involved in conduct that deserves charging regardless of their gender, is that one of the things Natalie Hodgson, Mark Trumbull, Barbara Holla have demonstrated in their research is a common unfortunate thread of these trials is to essentialize the fact that the defendant is a woman and attribute to her unfeminine traits as a way to sort of explain her criminality. Ilse Koch was reviled, as the polite New York Times called her the something of Buchenwald, but it was a stand-in for the bitch of Buchenwald, which is what she was known as. And all that was talked about was her supposed sexual appetite. Others, non-maternal characteristics, etc. This particular defendant apparently has 23 children, 18 of whom she's adopted quite recently, so we can only imagine that we'll see this thread comes forward again.
Thank you. Continuing in our conversation, Professor Mohammed, one commentator recently wrote about the arrest warrants as quote, Putin's Nuremberg moment. But he also noted that this is a moment for the ICC, for Prosecutor Khan, and indeed for the international justice community. with, for example, the slow pace of investigation in Afghanistan as a counter to the arrest warrants. I'd add to that the Putin arrest warrants came just days shy of the 20th anniversary of the US invasion of Iraq, which many consider to be an act of aggression. After noting that Nuremberg has had the taint of victor's justice, this commentator asked whether this Nuremberg moment might actually transcend Nuremberg itself, bringing with it equal access to justice for all, regardless of the status of victims or the perpetrators. What do you think we might expect to see out of this Nuremberg moment, including by the United States?
All right, big question. Yeah, this idea of this moment as a Nuremberg moment for today. So the first time I heard reference to that term, it came from Ambassador Beth Van Schok, and I think this phrase, a new Nuremberg moment, has been used in a few different ways. One I hadn't heard before today is, Diane's, I think, really beautiful connection between this moment and the Russia trial. I hope, that continues to be a way that we think of this as a Nuremberg moment. The primary ways that I've heard this term being used is first, the idea of this being a Nuremberg moment because the prospects for accountability are going all the way up to the top. A second is this reference to sort of a global consensus on the importance of accountability, and then third is the victor's justice dimensions. So in the first respect, I think, we can see the arrest warrant against Putin as an indication of the comfort with accountability for heads of state. Even though the ICC considers the matter of head of state immunity settled and completely clear as of the Bashir decision, that's not so clear in many other states. So we'll see how this plays out in debates, and especially if this becomes a practical reality, should Putin travel to ICC member states. On the second dimension, as I mentioned before, it's not so clear that there is a global consensus on accountability, right? There's no global consensus on the appropriate outcome of this war. There's not a global consensus on accountability mechanisms. There's not a global consensus on the ICC and its appropriate relationship to this war. On the third point, really, which I see as kind of the heart of the question, we can think about this Nuremberg moment, right, as a moment that represents the uncomfortable relationship between accountability and power, right? So why are we seeing this embrace of, say, an aggression tribunal for Ukraine and no accountability for the war in Iraq? So I think everyone in this room knows well the arguments about Nuremberg as victor's justice, and we may see a parallel, right, between the idea of victor's justice and the American support for accountability for crimes in Ukraine, even while the United States has pressed the notion, right, that there should be no jurisdiction over non-states parties to the Rome Statute, even while the United States disagreed strongly, to use Secretary Blinken's words, with the ICC's actions relating to Afghanistan. So how do we think about this, right? Is this a double standard? Yes, it's a double standard. Some have argued that the major difference between accountability for the war in Ukraine and the Afghanistan investigation is the complementarity and gravity standard. So the argument, as I've heard it, is that the United States has done enough to satisfy the complementarity requirement to displace prosecution in the ICC, and that with respect to US defendants, the gravity threshold for prosecution isn't met. I disagree with those assessments. I think they're incorrect. I think it's a double standard. Does that mean we should reject any embrace of the ICC by any state that has adhered to this principle of accountability for thee and not for me? I don't think so. The relationship between the United States government and efforts at accountability has been complex. I think it's important to recognize that the state isn't a monolith, that there are a multiplicity of actors within the US government with different interests and different approaches, both to the larger question of international accountability and to the particular question of, say, the jurisdiction of the ICC. At this point, this war has become a moment of change in the U.S. relationship with the ICC. We have new legislation that enables cooperation with the court. We have bipartisan congressional support for the court. Is there a double standard? Yes, but it's still a moment of opportunity, right? Maybe this is the moment when we can move toward dropping that argument that there's no jurisdiction over nationals of non-state parties. We've already seen the United States revise the war crime statute to allow for present-in jurisdiction. So this is a broad-based change that may well be inspired by the events in Ukraine, but it isn't limited to prosecutions related to Ukraine. So for those who want to see the United States support the ICC or support the broader movement for international criminal accountability for mass atrocity crimes, or even outside of the particular issue of criminal accountability, for those who want to see the United States engage productively with multilateral institutions across the world, I think we should both be cognizant of that double standard and also consider this a moment of opportunity.
Great, thank you. And thank you for that very pragmatic and yet hopeful assessment. Moving on, Professor Skoriatsa, due to Russia's position as a P5 member of the Security Council, its role as a non-state party to the ICC, which we've heard a little bit about, and Putin's position as the president of Russia, the arrest warrants trigger a number of issues. Could you, yes, just a number, can you provide a brief overview of the discussion that might ensue about a possible Security Council deferral under Article 16 of the Rome Statute?
Yeah, very briefly. Thanks for the question. Obviously, at Rome, it was clear that the court would have something to do with the United Nations Security Council. You're creating a permanent court. It's going to be intervening during conflict, not necessarily always post-conflict. So it was hotly debated at Rome what the relationship would be. In the beginning, actually, it was going to be the other way around. You would have the ICC prosecutor having to watch the Security Council and making sure it avoided whatever the Security Council was doing. That was flipped in the end. So now you have a particular mechanism in the Rome Statute where the Security Council can act by passing a Chapter 7 resolution, which essentially blocks a prosecution or an investigation for a period of 12 months. And from the perspective of post-conflict space that we need to negotiate, again, relatively distasteful to talk this way, but if we imagine that this conflict will end up in a negotiated settlement, there will need to be perhaps some sort of space created so that the negotiating parties can get around the table. What I think is an interesting, the legal technicalities are there, and you can see that there will be a debate about that. But what I think is interesting, actually, is where will this proposal come from for deferral? It won't come from Russia, surely, because Russia has already said that it doesn't recognize the court, it wants nothing to do with it, and you just can't imagine it coming from that direction. I can't imagine it coming from the European states on the council either, given that they have provided so much impetus and enthusiasm for the prosecution. Maybe it comes from China. And maybe one of the legacies will be that China takes a more active role in peace and security issues with all that that entails. So I'll leave it there and pass on to Marka because we're running out of time. So.
Thank you. Yes, and we hope to get maybe a question or two from the audience at the end. But Marco, if you could speak to one of the other issues, and that's head of state immunity. What do you see the Milosevic, the Taylor, or the Bashir cases telling us about the prospects for Putin raising this as a defense? And likewise, what might we expect from states cooperating with the prosecutors and the court's call for arrest warrants to be enforced?
Thanks, Katie. So the prior prosecutions of heads of state, the one thing they demonstrated that it's actually practically not going to happen while the person is still in power. The only exception to that rule is the Kenyatta trial before the ICC, where, of course, Kenyatta and Ruto used their mechanisms of power to completely obliterate the practical possibility that the ICC will convict them, right? So I, of course, am a citizen of a state whose head of state ended up on trial before the ICTY, something I took great pleasure in. But Again, it was only possible because we managed to overthrow him. Otherwise, it would not have happened. And that does not seem to be a likely scenario when it comes to Putin. Now, legally, the issue, of course, the biggest issue is head of state immunity. It only applies to him. It also applies to Sergei Lavrov and to the person who is the prime minister of Russia, whose name I cannot remember, because nobody cares, right? So it's only the three of them who enjoy this type of personal immunity. Nobody else does. No other Russian official enjoys this level of personal immunity. The debate here is basically between two competing schools of thought. There is the ICC appeals chamber in Bashir school of thought, which is that once a tribunal is sufficiently international, query what that means. Head of state immunity does not apply, not just for that court, but also for states that are cooperating with that court. So that if South Africa sent Putin to the ICC, it would not be violating the customary international law that regulates that relationship. That's the ICC appeals chamber in Bashir. The other school of thought, the one that I would say is correct, and that is really, you know, if you want to read the best sort of exponent of that argument, that would be my friend Dapo Akande, is that states cannot, simply by joining together, get more power than they have individually. So if Serbia and Croatia, you know, are not able to judge the president of Slovenia, simply by concluding a treaty, they cannot obliterate the immunity obligations they owe to Slovenia, basically, right? The fact that you have 10, 50, 60 states that do that does not ultimately change the calculus. Up to anyone to determine for themselves which of these positions is right. The entities that will make this final call are not the ICC judges. They've done their thing to the extent we or others regard them as persuasive. It'll be states who find themselves in the position to cooperate with the court or not. And Alonso Gurmendi, for example, on Opinio Juris, has written a post summarizing some of the state reactions so far. The reactions are positive in Europe. They do not seem to be, all other states are hedging as things stand. And we shall see what these other states do. Again, I very much doubt they will just embrace the Bashir appeals judgment without qualification.
Thank you, and thank you for those very succinct answers, which does give us some time for questions from the audience. So if I could ask if anyone has any questions to please come to the microphones in the middle, and we'll take a couple of questions and present them to the panel. And please introduce yourself.
Good morning. My name is René Provost from McGill University. And I want to invite maybe to contextualize differently the indictment against Putin by noting the serendipity of the indictment of former President Trump this week. Yeah. And we can relate as well to the events in Israel at the moment, which many analysts say are at least partly related to the indictment against President Netanyahu. And these speak to the way in which justice engages with authority at its highest level as moments of danger, but also as moments that are, in fact, essential for any justice system. And this reminds me of historical studies of the role played by criminal law in England in the 18th century, at a time where there was no police force in England, unlike in France. And there's wonderful historical studies about how, for example, the hanging of Lord Ferrers for assassinating his steward created such reverberation legitimating the criminal law as a whole for decades, if not centuries, despite the fact that criminal law was, in fact, radically unfair or unfairly applied, and that basically the nobility was never prosecuted. But Lord Ferrers was, and hanging is hanging. And it connects with Professor Mohammed's point that the narrative force of such cases is such that it can overwhelm many of the weaknesses of the international justice system. So the question becomes, is this a win-win for international criminal justice really nearly assured? And what exactly is the scenario where this ends as a failure for international justice? Because we might say the ICC has been a 25-year story leading to this moment, right? It was always about whether it could go that far, and it has. So it's unlikely to fail in a manner that overcomes the achievement of the indictment. I'll stop here.
Thank you, yes. And can we go on to the next question?
This is
But thank you
a
for
very
that.
brief comment. I'm Semi Payne at Rutgers University. Wonderful panel. I just couldn't help standing up to invoke Ben Ferencz, who may be in the room. I saw on the internet he's 103 years old, and so I leave it to the panel to explain why I should mention him.
Thank you. Thank you for acknowledging our esteemed elder. Any other questions, or should I turn it back over to the panel? I'll turn it back over to the panel, and we can go down the line in this direction with any reactions or last reflections.
Yeah, my last reflection is just essentially that the shape of post-conflict criminal justice often depends on really messy politics. And although this is, and I share a lot of the enthusiasm and certainly all of the solidarity with the Ukrainian people here, we have to just wait and see whether the ICC ends up playing any significant role in this. It could be that there is a new institution located in Ukraine, a bit more localized, agreed to by the parties, and something a bit more akin to what you got in sort of Colombia that might happen. And I would be perhaps in favor of something like that. But yeah, incredible moment, and thanks for inviting me.
Thanks for those questions and comments. I guess I'd say, in answer to the question of what does a failure look like, I think in the very short term, from the perspective of just keeping our eyes on the court, I could imagine a failure looking like, Bashir traveling through South Africa and not getting arrested, right? Like if that happens again, I think that's going to be a real failure for the court. But I also think that we shouldn't be thinking about this arrest warrant in the short term. I also don't think we should be thinking about the ICC on its own. I think this question and this panel is a reminder to think about this institution as one of a number of international institutions and also domestic actors too, right, that are all a part of bringing the war to an end. Accountability to the extent that that is an important step to be taken, and then rebuilding after the war, that we shouldn't be thinking about accountability as the goal in itself, but rather as part of the larger project of recovery and stability.
I almost injured myself with the microphone. So, Renee, I accept very much your point that there is a ritualistic aspect to prosecuting the powerful, of subjecting the powerful to the law, right? I'm echoing Robert Jackson also at Nuremberg. Israel is actually a good example. I mean, it's a state that has incarcerated more prime ministers and presidents than probably most other countries for various offenses, yeah? It is now that, of course, the institutions of that state are shaking, that the law shows its weaknesses to power, right? Now, I think it would be wonderful for the ICC to, or some other court to eventually prosecute Putin successfully. I doubt that this will happen. It would be wonderful to see that. My one reservation is that those states that have themselves done things that are as bad cannot just pretend that never happened. The failure scenario is that other parts of the world simply start treating the ICC as an instrument of the West, and that's it. That's the failure scenario, that the ICC is not perceived as legitimate in the eyes of Brazil, not in the eyes of Russia. Yeah? And I very much think that depends on what Western states do now. I find it shameful, yeah, that there are people who are vastly more culpable for international crimes in this country who walk around and do whatever they want, while there's angst about Donald Trump being prosecuted for, paying money to Stormy Daniels. I think, you have bigger problems in this country than that. Let me put it that way, Or that biggest proponent in the United Kingdom for a special tribunal on aggression, Gordon Brown, the former prime minister and chancellor, is the guy who funded the war in Iraq. I really think that is a problem. And if you come from some part that's not the United States or like core Western countries, you will find that delegitimizing. And that's, I think, one thing that Western states must work on.
So I feel compelled at this point to note that I, too, am a dual national and am a national both of the non-party state, of course, as you can tell by my accent, that was just properly, and by many people here, called to account. I am also a national of a party state, donor state, and referring state of the arrest warrant in this particular matter, the Republic of Ireland, and in commemoration of the, I believe, 25-year anniversary of the Good Friday Agreement, which I believe is this week. I too want to end on a note of peace and imagining peace, as Javier has mentioned. Even as we think about war, we think about violations of war, we need, even in the worst, to imagine the peace and work toward the peace. And Christine Bell, in particular, has written a really masterful set of case studies that demonstrate what we do during the conflict affects the peace agreement and any post-conflict justice afterwards. So, for instance, what she found with regard to Ireland, the discourse of human rights and international law continued throughout the 20 years of the Troubles. It was always part of the contestation. And in her view, that is why the Good Friday Agreement is a human rights instrument and continues 25 years later to operate as such, setting up institutions and creating a culture of human rights. She contrasts Bosnia as the opposite in all regards. And so that, for me, is a demonstration that doing things like foregrounding crimes against children and demanding through arrest warrants that children not be treated this way. And we can imagine the prosecutor promised that there will be more applications for arrest warrants, that other behavior is unacceptable, itself will help construct the imagined and indeed hoped for peace with regard to this war. Thank you.
Thank you. I think that is the really perfect note to end on and call for peace and for justice, but really to have peace and a deterrent value now. So with that, please join me in thanking this panel for covering so much in such a short period of time. Thank you all.